Hello and welcome to Minnesota Landlord Law. My name is Brad Sheppy, and I'm a real estate attorney who specializes in landlord-tenant law, commercial and residential. All you need to do is go to our website, minnesotalandlordlaw.com, click Start the Workshop, and now we're going to navigate specifically to the module today, which is addressing maintenance. Topic today is in-unit property maintenance, right? So obviously a big difference between fixing something on the exterior of the building versus inside. Before COVID-19 really was about noticing tenants, cleaning up after work is done, and timely doing the work by maintenance or a contractor. Now we have tenants at home almost all the time during the peacetime emergency in Minnesota, and those folks have, rightfully so, concerned about people coming into their unit, are they sick, etc. So the purpose of this module is just to go over a few of the items and options that management companies and landlords in Minnesota are currently doing, briefly touch upon the law, and then tie into, if you have any questions, how I can help further. So I lay out specifically here 4 different options that landlords are currently considering in this new era. The first one here is to suspend minor maintenance that does not materially affect the property or health, right? That basically means right now, if you have a minor maintenance request, we'd like to receive it, but we're not going to go into your unit. That's a very clear, strict policy. And that is one option that a management company can take. Another option is, well, if you do have a minor maintenance request, we're going to limit that service to dropping supplies at your door for now. If your drain is clogged, if you have pests, things like that. Another option is essentially status quo. If you have a maintenance request, someone's going to come in. Could be a tech, a contractor, and preferably, obviously, with gloves and masks. Fourth option would be to, if there is a minor maintenance request, trying to work out a time with the tenant when they're not there. So there is no issue about 6 feet or comfort level with folks in the unit. Legally speaking, I just wanted to cover it briefly that the reason this all matters is because there's what's called a covenant of habitability. Go back to the statutes. The landlord is responsible for a unit to be habitable essentially all times. And if there's any violations, meaning a code violation, if there's something's broken inside the unit, that the landlord needs to go in and fix it. And so that's why this all matters as to what are we doing and why. And if a landlord decides to delay maintenance, is that an issue? Well, ultimately, it all ties back into the law. If you have more specifics, you can contact me directly. Legally speaking, let's say, for instance, a tenant notified you, the landlord, and you did not do anything for 14 days. Prior to COVID-19, they could start what's called a rent escrow action under Minnesota Statute 504B385. They have a request in writing, 14 days have passed. The courts have put a pause on that as well. Those cases have been given low priority. However, if there are permitted still emergency tenant rent escrow actions under 504B381. So if you have a tenant says we have a loss of running water, heat, electricity, or the landlord or someone else discovers that still needs to be done, obviously, immediately. It's almost goes without saying, but just also know that legally the tenant still has that ability to go to court, even in this emergency. Lastly, and if management companies or landlords are now getting in the business of advising tenants to do your own maintenance, do your own work, it's an emergency, please know that there still is an underlying statute that basically states that if tenants are requested or required to do maintenance, that can only be supported by adequate consideration as set forth in conspicuous writing, meaning it's got to be in writing and the tenant has to be paid or compensated. It has to be either, as stated here, money, rent reduction. And so maybe these minor issues getting away with putting supplies at their door is just part of an emergency and not an issue. But if you go beyond that, please know that at the end of the day, the law still requires landlords and management companies to compensate them. You can come up with a flat fee. If they do their own drain clog or pour Drano in that you drop off the door, you could give them a $30 credit or something like that. So in summary, communication is key with tenants. They're all going to have different types of comfort level or not, but to have a consistent policy would be best. So lastly, as a part of most modules, I either have a notice or a contract or some type of form or document. Module 7 is no exception. Here I have a specific COVID-19 maintenance notice that goes out to tenants. And I have it right here. And essentially you see here, it's broken down like we talked about before to maintenance emergencies. Those folks are going to go in. Minor maintenance requests, how to communicate those, how to be proactive and use upload photos for maintenance. So maybe no one has to go in. Just essentially to work through options and communicate how you'd like to work with them. This template can be modified as necessary with no issue whatsoever. So lastly, in closing, we're going to pull back up the module. At the bottom here, you can subscribe to workshops, putting your name and email in it, as well as you can click to move forward to module 8, which will be uploaded shortly, or you can click through and navigate back to modules 1 through 6. Again, I'm Bradley Sheppy from Minnesota Landlord Law. This is my website. I welcome your feedback. Feel free to reach out to me, and you're welcome to click and schedule an immediate call on my website without any time delay. Good luck out there. Take care, everyone. Bye-bye.